Thank you and good morning. Today is Friday, February the 27th, 2026. This is the Board of Professional Bondsmen meeting. This meeting has been previously scheduled. My name is Roxana Gamusio. I am the Executive Director with the Board of Professional Bondsmen. As first order of business, I'm going to do roll call vote to make sure that we have quorum, and then we will proceed with the agendas that's been presented. Members, if you can just let me know when you hear your name called out, then we will proceed. Judge James Turner.
Here.
Thank you. Sheriff Russell Baker.
Here.
Thank you. District Attorney General Jeffrey Thompson.
Here.
Thank you. Clerk of Courts Rex Links.
Here.
Thank you. Bondsman Shelley Alexander.
Present.
Thank you. Bondsman Anthony Kirkland.
Here.
Thank you. And our newest appointment, bondsman Kyle Turner.
Here.
Thank you. And members, going forward, I will remove the positions, but I felt it was important to just get all of the different appointments out. And so we're starting our meeting right at 10:30. Notice of this meeting was posted on the board's website, and it's been there since December 31st of 2025. This specific agenda was posted on February the 13th of 2026. If there are any public comments regarding the agenda and business items during the new meeting section of the agenda, I will pause and make sure that anyone that has questions about what's on the agenda, not the rulemaking hearing, can ask those questions, and we'll address those, as well as anyone that is participating through WebEx. Those participating virtually have a link to WebEx. Dana Lee is with my team, and she'll make sure that their comments and questions are also addressed, and we'll make sure to stop for that piece as we get to the end of our meeting business. Members, the agenda is the first item that we need to approve. It was emailed to everyone. If you have a chance to review it, it's also on your iPads. And if you have any questions, I'm happy to answer. Otherwise, we would need a motion to accept the agenda as it's been presented.
So moved.
I'll second.
Thank you. We have a motion by Judge Turner and a second by Shelley Alexander to accept the agenda. All those in favor say aye. Any opposing? Hearing none, the agenda will move forward. On your iPads, you have the minutes from the November 25th, 2025 meeting. This was our first board meeting. If you have any items that need to be changed, please let me know. This also was emailed to our members. If there are no changes, I would contemplate a motion to accept. Thank you. I have a motion by Anthony Kirkland and a second by Judge Turner. Is that correct? Thank you. All those in favor, please say aye. Thank you. Any opposed? Hearing none, that takes care of the agenda as well as the minutes. Next, this is our first meeting for 2026. So as first order of business, we need to adopt following Robert's Rules of Order. That's one of the items discussed when we do board member orientation. We also have our wonderful attorney, Ed Williams, here with us. If there are questions about following Robert's Rules of Order, we're happy to address those now. But if there are none, this is how we carry out our meetings and do motions. I would need a motion to accept that we will be conducting our meetings following Robert's Rules of Order. Thank you. I have a motion by Rex Links and a second by Shelley Alexander. All those in favor, please say aye. Any opposed? Hearing none, that takes care of how we conduct our business. Next, again, this is the first meeting of the year. This is also something we'll need to do each year. And being the first meeting, we will need to elect a chair and a vice chair by statute as part of the board. I will open the floor for nominations for both, and then we can proceed with voting.
I nominate Judge Turner for chair.
I'll second.
Who was the second? I apologize.
Me.
Thank you. We have a motion by Neil Thompson to nominate Judge Turner as chair and a second by Anthony Kirkland. By roll call vote, do you want me to roll call or just all those in favor of going with chair being Judge James Turner, please say aye.
Aye.
Hearing none. Okay. Are there any other nominations for our chairs? I would contemplate then a motion for our vice chair.
That's what.
It's not that bad, I promise. Okay, we have a motion by Anthony Kirkland nominating Neil Thompson as our vice chair, and the second came from Mr. Lynch. Thank you. We have a chair and a vice chair going forward for 2026. All those in agreement of our newly vice chair, Neil Thompson, please say aye. Any opposed? Hearing none, thank you. That is the hardest part of today's business, at least for me. Thank you very much. Any questions regarding the nominations or that process? All right. Members, on your iPads on page 4, you have the financial records. These are through the month of December. You'll always get this update. There's no motion needed, but this is informational. It includes our expenses since there was no revenue. This is through December 2025. The board is at a deficit of $103,170. Those are all the expenses of technology, research, legal, that have come before that. At the next meeting, you will see all of the revenue that we will have from February's bulk licensing things. The next item, just to update the board and see if you have any questions. We have launched, of course, the licensing for our bail bondsman companies, as well as our individual bondsmen. As of yesterday, we have 454 professional bondsman applications received, and this is for the individuals. 74% of those have been approved. A lot more came in last night and today, so we expect to be busy approving those. If there are any deficiencies, such as the FBI report was not submitted, the judicial district was missed on a particular district, then we are communicating via email. It seems to be going really well. We're getting quick responses for anything that's missing in order to proceed. Regarding our companies, we have 132 companies that had applied. 66% of those have been completed. My team is 4 individuals that is doing licensing. Angela Nelson is here with us today. She is my right-hand person, my assistant and everything. I'm the only one approving right now. We just felt that until we get through the bulk, it'd be better if we have that consistency at the end. I am available via email and phone, probably Monday through Friday. The hours are long right now because we want to make sure to answer everybody's questions, and hopefully that'll all be wrapped up next week. Any questions, members, regarding our process?
Just a question. You said how many had been approved?
So of the individual 454 that were received, 74% have been approved.
And of just a ballpark, how many in the state of Tennessee would you say are in the state of Tennessee?
That's a good question. We had
Ballpark.
heard from the association close to 1,200 maybe. And so it could be that many. We'll find out soon enough. And then companies, the number we kind of had an idea of was 200. 132 had applied. Easily 24 more came in this morning, just when I peeked. 66% of the companies have been approved.
I believe you're going to see that there's actually right at 500 companies.
Okay. Then we've got a lot more companies coming in. That is all that I have for board business. I'm going to go ahead and, since this turns over to the rulemaking hearing, and it'll be turned over to Ed Williams and Jesse Gentry. Are there any comments regarding the items on the agenda that we need to address? Dana, if you'll let me know if anyone on WebEx had questions about the particular agenda so far. Ed, I don't see any. We can always still take those at the end, so I'm going to turn it over to you, sir.
Okay, again, my name is Ed Williams. I am legal counsel for the board. The first thing I need to go over is legislative update. Thus far this year.
You want
Oh,
to distribute? Or not?
As far as legislative update, there has been no legislation that we have seen that would affect the board this year. And then we'll move on to rulemaking. This rulemaking hearing is called to order. Again, my name is Ed Williams. I serve as the Associate General Counsel in the Department of Commerce and Insurance, Division of Regulatory Boards. I represent the Board of Professional Bondsmen in this rulemaking today. Would the agency representatives who are present introduce themselves for the record? We'll start on the left-hand side and work our way around. Just speak into the microphone, sir.
Kyle Turner. Andy Kirkland.
Shelley Alexander.
Rex Lynch.
Jimmy Turner.
Neil Thompson.
Russell Barker.
Roxana Gamusio.
Right, and I'll remind some of you that your mics are still hot. I apologize, my computer just signed off on me. It is Friday, February 27th, 2026. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 45204 in Room 1B of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on proposed rules the Board of Professional Bondsmen has made public. The proposed rules are in response to statutory changes made with the passage of Public Chapter 491 in 2025, which went into effect January the 1st of 2026. Specifically, these rules create the procedures, fees, and standards related to professional bondsmen. These rules outline the requirements for the administration of this law, both for professional bondsmen companies and professional bondsmen. These rules also address the qualifications for all professional bondsmen. Specifically, these rules outline the requirements related to the application process for initial approval and reasons they may be denied. Additionally, these rules further outline requirements related to documents that must be submitted for approval, as well as align them with the new fees for application. These rules outline when a change of information is required and highlighting when notification of the board is required within 72 hours. Additionally, these rules outline disciplinary actions as well as the potential fines involved for violations. A rule is defined as an agency statement of general applicability that implements or prescribes law of policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of Secretary of State. Notices given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet located on the podium. Those members of the public wishing to speak and appearing via WebEx should put their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet or typed their name in the chat box. Is there anyone who desires to offer Is there anyone that desires to offer oral comments but who has not written their name on the sign-in sheet or typed their name in the chat box? Seeing that there are none, we have one. Okay. I'd like to call your attention to the table that's directed or located behind me. On this table, you'll find red line copies of the rule amendments. Rules or amendments addressed in today's rulemaking hearing. For those attending electronically, you will find a link for the rules under the notice tab on the program's calendar online for today's hearing. The notice of rulemaking hearing included the entire text of the proposed rules and was published on the Tennessee Administrative Register website on December the 30th, 2025. An electronic notification for these rules and this rulemaking hearing was sent through the e-notification system on December the 30th of 2025. Notice of this rulemaking hearing was added to the program's public agenda and the calendar on February 20th, 2026. Ms. Gamuccio, what additional notice was given to affected individuals or groups?
Thank you, Ed. Notice of this rulemaking hearing was emailed to our board members on January the 5th, 2025, for them to forward to their individuals that they deal with, courts, clerks, the TAPBA. And then separately from that, it was put on the board's website. And then we also broadcast to those signed up to receive email notifications through my Emma. All that took place January 5th and 6th for proper notice.
Okay. As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will summarize the substance of the proposed rules into the record. The following new chapter, listed as Chapter 20 and identified as Professional Bondsman, is being added to Tennessee Rules and Regulations, Chapter 0780-05. These rules, as identified below, will be added to this new chapter. Rule number 0780-05-20-.02. Definitions. It creates definitions of words that are commonly used by the state and the industry. Rule 0780-05-20-.03, qualifications, applications, and fees. This rule outlines the qualifications, what must be included with the applications, and what fees are associated with the application. Rule number 0780-05-20-.04, review of applications, states that the board or designee may deny an application for any violation of Title 40, Chapter 11. Review of applications may be done by the director. Rule 0780-05-20-.05, change of information. This rule outlines timelines that bondsmen and companies must notify the board and any fees associated with that change of information. Rule 0780-05-20-.06, disciplinary actions, allows the board to assess a civil penalty, suspend or revoke the license for any violation of Title 40, Chapter 11, or any rule promulgated thereunder. The following items were amended from the emergency rules. Any place in the red line or in the emergency rules that you would have seen TCA 40-11-314, any place that TCA appeared, it has been changed to TCA 40-11-321. This was due to a competing statute that had the same TCA number. Any place where you see rule number 0780-05-19, or any place that rule number appeared, it has been changed to rule number 05-20. Again, this was due to a competing rule that had the same number. The next thing, requesting permission, I as legal, I'm requesting permission to amend in Rule 0780-05-20-.03 under qualifications, applications, and fees on page 3 of the packet, number 2B and number 3B. I'm requesting to delete the words receipt or proof of a, and that would make 2B then read a completed background check instead of a receipt or proof of a completed background check. And on 3B, it would be the same, except it would then state a completed background check for each owner of the professional bondsman company instead of a receipt or proof of a completed background check for each owner of the professional bondsman company. The reasoning for this is that the application process cannot proceed forward without actually seeing the background check. And this presented a stumbling block to us as we started to process the applications to see if the applicant actually meets the qualifications. So I would ask that be put in the form of a motion.
Before we go there, if you read under this public chapter, section 12, Tennessee Code annotated section 4011-317A is amended by deleting the subsection and submitting the following. In addition to any other qualifications required by law, a person seeking to become a professional bondsman shall file an application for licensure with the Board of Professional Bondsmen. In addition, the applicant must submit a criminal history background check by the Tennessee Bureau of Investigation. That does not say FBI. And the fingerprinting is what is held up and caused a lot of problems. That is why people are getting rejected. That's the complaint that I've heard the most. When the public chapter just requests the TBI, which we can get the TBI easily through the TBI website, have it within a day, and the results come directly to us. However, we are having to go be fingerprinted, do a special fingerprint through Identigo that our board doesn't have an ORI number for, so the results will not come to the board. We've had to maneuver a way to get the results to come to the individual. By doing that, we are selecting a choice that says these fingerprints are not valid for licensure. And when the results come in, it says not provided for purpose of licensure. And that's what we're having to submit.
Ms. Alexander, what statute was that again?
It is in the new public chapter, section 12, and it's section 4011-317A,
Section 12A.
12A in the public chapter. And this is concerning me because as of March the 1st, our sheriff's department are fixing to be backlogged if these bondsmen can't post bond. We're cutting it in a third. We've got to figure this out.
Mr. Williams, do the rules currently require, I mean, what you just read and what I see before me, it doesn't say FBI or TBI. Does it say it somewhere either in our emergency rules or in these new rules, FBI?
Just a minute, Judge. Let me
Yeah,
pull
take
that
your
up.
time.
Judge, in reference to your question, is if it was listed in the emergency rules, it is not specifically listed that the check come from the FBI. It says a completed background check. In the actual TCA, it does say an FBI background check. However, the ones that control the FBI background check is not a state agency, it is a federal agency. We have applied for that ORI number from the federal agency, and we have not heard back from them. That application was made back in November, as soon as we started coming across this information. The attempts here in the rule is to allow us to go forward with our licensing program and assisting the bondsmen in ways that they can still get a background check and forward that background check to the board for the board to review to see if they meet the qualifications.
So it sounds like these new rules take out the mention of the FBI.
That is correct, Your Honor.
All right, I move to accept the amendment. I don't know if, I don't know if the board chair can really, I don't know if I'm in a position to move, but
It's not in the rules, it's correct. It's in the law, we can't do that.
yeah, I agree. Is there a,
Well, we need to figure out because the TCA code says. It's in the law, I'm not understanding.
Chairman Turner, it is not listed in our rule that they're required to get an FBI check. However, a full background check is what the rule specifies here. So if they go through the steps as we are directing them, they are able to acquire a complete background check and forward that to the board so that we can make sure that they meet the qualifications. And while this is taking place, if we do get an ORI number, we will have to come back in and amend our rules to add the FBI check specifically.
okay, ladies and gentlemen, this is not the time for public comments. There's certainly a part of the agenda for that. Sir? We can ask you to leave. Thank you. I think Mr. Williams asked for a motion to amend these rules in 2B to remove the language, a receipt or proof of, and then in 3B, a receipt or proof of. Is there a motion for that?
I make a motion to modify 2B and 3B to remove the language a receipt or proof of so that it'll reflect just a completed background check.
I apologize. Who did the second come from? Mr. Kirkland, thank you. We have a motion to proceed with the change made by legal counsel by Neil Thompson and a second by Anthony Kirkland. I'll turn it back over to you, Ed.
All in favor, say aye. All
Aye.
opposed, ayes have it.
And just a point of order on that, Mr. Chairman, that does not change the TCA requirement. That only changes our rules, which allows us to adapt to what we have control over. And I apologize. Give me just a second to find where I was. Okay, this concludes the summary of the rules being considered today. To inspect or review the exact language of the rules, please refer to the instructions previously provided regarding access to the text of the rules. We will now move on to public comment period of this hearing. Ms. Gamuccio, were there any written comments received by the office?
No, there were not.
Okay. I myself have not received any comments specific to the rules prior to this hearing, although I will note that we received questions about individual compliance and comments on related legislation to these rules, but none specifically to these rules. Are there any public comments from those present at today's meeting, either in person or via WebEx? Yes, that's fine.
Dana, this is Roxanna. If we can go ahead and do the chat first, and if you have any more, they can proceed. We've got at least 3 or 4 signed up here. So I'll let you go ahead and start and unmute those individuals. Thank you.
Okay, I've unmuted Jason Holt.
Yes, how are you today? My question was in regards to the FBI and TBI background checks. The way the website for the state or the board is now, it requires both in order to proceed. So at this point, after today, we only have to do the TBI.
No, sir, both are required. However, you will not be able to do the portion that requires the FBI to send that report directly to the board. What you will have to do is get a copy of the report yourself and send that to the board.
Excellent. Thank you very much. That was the only question I had. Thank you.
Thank you, sir. Dana, do we have anyone else?
I'm
Hearing
scrolling through
none.
the chat, trying to see if there's any other names added.
Okay, we're going to go ahead and proceed with those that are here in person in the order they signed in. And then Dana, before we go, I'll make sure if anyone else has added that they'd like to speak through WebEx, that we have that opportunity. So thank you. Joel Mosley. Thank you.
Ladies, gentlemen of the board, members of the staff, I appreciate the opportunity to speak to you today. Generally, I have 3 concerns that I thought needed to be addressed at this meeting before there was any approval of the regulations. And in particular, I just want to go on the record and say that I would suggest that before you finalize the regulations, that you do consider these. And it might be wise, or I would submit that it might be a good idea to delay the approval of the regulations in general until after these matters have been sufficiently discussed. In particular, begin with, as a matter of concern, under the proposed rule titled 0780-05-20-.05, in particular subsection 1, there is a reference to the statutory requirements under TCA 4011-319. TCA 4011-319 does require the reporting of certain arrests by the professional bondsman. And that arrest is felony charges. It does not include misdemeanor charges. Additionally, the entity that has a duty to report is the individual agent and not the company involved. The regulation that's been proposed would place a burden and raise the issue of disciplinary action against a company for failing to report an agent's failing to report to the state. And in essence, I would submit that if an agent is unwilling to report to the state, they're certainly going to be unwilling to report to their employer. The employer has no greater information than what they get from their agent as to the arrest record, and as such, I think they would be in the same position the state would be in, and that is left in the dark until such time as somebody raises that issue. And in essence, I would think the state of Tennessee would be in a better position to know whether somebody's been arrested than the employer. So I would suggest that needs to be amended to reflect what the statute requires and not what the expanded scope that's in there. And I understand the desire to expand that scope. That's an issue that was litigated in Ray Cumberland bail bond many years ago. And one of the concerns that this court had was that the company was not reporting the malfeasance of the individual bonding agent. But what the Court of Criminal Appeals held was that you can't hold the company responsible for the duty of the individual bail agent. So in that instance, I do think there needs to be a significant rewrite of that. Now, I do want to say that just as a point of style, that in the definitions section, in particular definition 3, there is a reference to professional bondsman company. And as a term of art, I've never heard anybody refer to a bonding company as a bondsman company. They refer to it as a bonding company, not a bondsman company. So I would suggest that if you wish to be consistent, that the company and professional bonding company would probably be a more accurate way to term that. The professional bondsman is a term of art and the definition that is made in statute, but the company itself is referred to as bonding companies. More troubling than any of that is the lack of specific regulations regarding violations of 4011-125 or disciplinary action under 4011-125. When the Public Chapter 491 was amended, in particular when they adopted sections 3, 4, and 5, the shift was made from disciplinary actions from the courts to the Board of Professional Bondsmen. And all the factors and all the issues that the courts had handled up till then were shifted as a result. Now, in this proposed regulation, we have 0780-05-20-.06, and we have 2 subsections. And those 2 subsections are very broad and very ill-defined. In particular, the current language of 4011-125 requires that actions be taken after an investigation. And the regulations as proposed do not have any reference to an investigation. Who would conduct that investigation, how that investigation would be reported, to whom it would be reported, much less what would occur after that investigation is concluded, namely the statutory due process requirement that the bonding company be advised of any action taken. So I would submit to the board that the language of 0780-05-20-.06 needs to be extensively rewritten to reflect the language of 4011-125 and those due process rights that are guaranteed under that statute. At this point in time, there are a number of actions that should be pending before this board with regard to allegations of misconduct by bonding companies. But unfortunately, there's no comprehensive way in which those are actually reported and handled by this board. And as such, I think that there needs to be an extensive overhaul, and those procedures need to be memorialized in these regulations. I don't want to take up this board's time. I know that you have got a lot of things on your mind. You've got a lot of people behind me that probably have other concerns that need to be addressed as well. But I did think that in particular, those 2 matters, the change in the reporting of arrests and the need for additional procedures with regard to the misconduct of bonding companies and how that's handled, those need to be addressed post haste, and they need to be addressed comprehensively. Thank you for your time, and if you have any questions, I'd be more than happy to answer them. But we've got some other people that are here, and I want to give them the time as well. Thank you very much.
Mosley. Thank you.
Don Williams.
Good morning, Board. How are you? A couple of you know me up here, quite a few of you don't. Got some major questions about the website, how much we're being charged as company owners. I'm flabbergasted by the amount of money that I'm going to have to put out. One of my main concerns is why am I being charged $500 for the company that I own, and then $100 for each of my agents, and then I also have to pay $250 on top of that for me and my husband to be the owners. I'm a little lost in all that. The website that I've been dealing with for the last 2 weeks keeps continuously kicking me out every time I try to upload documents and try to get it over to where it needs to go. The Identigo thing, over in my area, we're on a 2-week backlog. I can't even get into the sheriff's department to get it done because they've got new deputies coming in and out, everybody going through what they're going through over there. Multiple companies have had to travel out of town to go get their fingerprints done. Being a little itty bitty company, you know, I don't have time to leave my area to travel 2-3 hours to go get my fingerprints done. And then trying to get that over to the board. I have called and asked some questions. First, it was all gravy. And then when I had bigger questions that needed to be answered, as the owner of the company, I was told those questions were not going to get answered and my application was going to get canceled. I don't like being told that. I've worked 30+ years to have my company. And for somebody to tell me, because I asked a question that couldn't be answered, that my application is going to get denied, that's unprofessional. I don't mind paying into a board as long as I know what I'm paying for, how things are going to get regulated. We have a TCA code 4011-316. We are required by TCA code to collect a certain amount of money for these bonds, no less than 5%. We have bonding companies out there still charging between 1 and 3% to undercut the competition. We're supposed to be in this together and help each other make money, not backbite other companies. How are we going to regulate that? Who on the board is going to regulate checking receipts, auditing these companies to make sure that their receipts match their bank deposits? I haven't been able to get any answers on that. Monroe County implemented every time a bail bondsman now comes in to write a bond, we have to present the receipt showing we were paid and that it was done properly. That's the only county in my districts that I've been able to get to help me with that. Who on the board is going to regulate this? Who's going to check in to make sure with all these rules that we're getting that everybody else is going to comply? The companies like me that are family and veteran owned and based, and we do it with integrity, we comply with every TCA code there is. I've got a Bible and then I've got my TCA code Bible. I live by both. And if we're going to do it legally, all these other companies need to be held accountable as well. But who's going to regulate them? There's no...
Judge, I can't hear your mic.
You said pardon? Thank you very much, sir.
Thank you, sir. It's great that we have a board that's wanting to make moves and finally do something to make sure people are held accountable. And I'm happy with that. But we need to know, as owners, what departments are what department the money is going to, where it's all going to, how it's going to be implemented to help us, not hurt us. If I have a question, let's say Shelley is Miss Alexander's, divvying up money to this department over here. If you have a complaint about somebody not doing their job as far as writing receipts and collecting the proper money, can we call her to find out what's going on? Can we call Miss Roxana? Hey, what's going on with this? We need clear answers. The website is horrible. I have literally created 6 different email addresses to try to get logged in to apply just for me. We have our company email. That one went okay for a little bit. I called Miss Roxanne, and then it started kicking me out every time I tried to load documents. Then I had to create a different email account to do it personal on just me as the agent, and it wouldn't accept the email address at all. The TBI background checks, nobody has an issue with. We do them every semi-annual. But now that we implemented the FBI thing, it's like pulling teeth to get anything done. And I just, as the owner of the company, I want some answers. And I'm not getting any help when I'm asking questions. Why do we have to, as the owner of the company, pay that extra fee to be an agent of our own company? We pay the $500 for the company. Then we have to pay $250, and then we have to pay $100 for each of the owners. And then we have to turn around and pay for our agents to hang their licenses on our wall. And then they have to pay $250. It seems like there's a lot of money going out there for something we've already done. I paid for my business license. I pay my taxes. And now we're paying for our business again. For somebody to regulate us when we've already been self-regulating under the courts. I'm just confused as to why so much money is going out, and I'm not getting answers. And if it was, well, there's a couple of owners up here on the board, but if it was y'all's money, those questions should be arising as well. And I know as bondsmen, we don't have an easy life. We answer 3,000 phone calls a day if we're lucky. And we have to answer questions for the people that we bond out, their co-signers, their family members. So when I call and I ask questions, I get told my application's going to get denied and canceled. And I'm pretty sure I'm not the only one in the room. Questions mean answers, answers mean power. And that's knowledge that we all need. Not a ton of TCA codes and new laws that everybody feels like we're being attacked for being bonding companies. I know quite a few really good bondsman company owners that do it the right way. So all of us that are doing it the right way are falling victim to the companies that aren't doing it the right way.
Ma'am, we will have a separate public comment period at the end. This is the public comment period related to these rules.
Yeah.
So specifically, if you have comments on the rules themselves, that is what we're soliciting public comment on today.
Yeah, the rules are going to apply to us. How are we going to regulate?
Yes,
the
ma'am,
people
but the
that aren't
question,
doing it?
the comments regarding the website and anything that's separate, we can address those later. We're here to solicit comments on the rules themselves. We would like to hear during the public comment period separately about other matters. This is specifically about the rules. I don't mean to cut you off.
Yeah, no, the
but
rules are on that website, but the website's not cooperating.
Yes, ma'am. I understand your concern. These are something that we can address separately with our board staff to help you individually, but specifically the purpose, while we have a court reporter here today, the purpose of posting this is to solicit public comments on the rules as part of the requirements to solicit comments on them.
The requirements are that website. Young man, when I get on that website and I cannot get it to cooperate,
I understand that
that's one of the
see
rule
these as the
requirements,
same.
is it or is it not?
You can
the
make an
rule
application and you can make an application. I understand if you're having issues with the application process. We're looking specifically at the substance of the rules. That is the purpose of the public comment period today.
The website is part of the rules. Is it or is it not?
The website is not contained within the substance of these rules. These rules do not mention the website.
So what you're telling me is that that website is not part of the rules.
What I'm telling you
Correct.
is that you can make an application and we will assist you with the application. We're happy to
When I
assist you.
call for assistance, I get yelled at and get told that my application is going to get denied because y'all's website is not working properly.
I'm not sure who you spoke with, so we were happy to talk to you after this meeting or after this period, but this is specifically related
The
to.
rules, that website is in what you guys say is required. Required, which means it's a rule. It's required that we do it.
These comments are not related to the substance of the rules. So as moderator today, we will have to limit these comments to the substance of the rules. We're happy to talk to you about these specific issues, but we have public comments. We have a court reporter to solicit these comments for the rules themselves.
All right. Have a blessed day.
Thank you.
Nathan, I think you're next. Nathan Ridley.
Your Honor and members of the board, thank you, and Mr. Chairman. Thank you for the opportunity. I'm Nathan Ridley. I'm a member of the Nashville Bar. I serve as legislative counsel for the Tennessee Association of Professional Bail Agents. Just a few comments about the rules. This is a heroic task, and we might be some growing pains here, but just specifically in Rule 0.02, I don't remember all the numbers, but just Rule number 2, it mentions designee of the board. The board had, to me, my understanding is the board has the responsibility to license the folks that will be licensed, the companies and the agents under this. When it says or designee, we are grateful for the staff's efforts to help get our folks, but who is that? And maybe we don't need a name, but a title or something just to know who that, because right now it's sort of vague. Ponder that. And it's hard to address all these, and I'll be very brief, I promise, but it's almost a red line version, and maybe when I conclude, I might say maybe tap the brakes and take another run. But just who is the designee? Mr. Mosley addressed the issue of misdemeanor arrest. I think that might be beyond the scope of the statute. We might want to revisit that as we proceed here. And I guess, again, just to reiterate a little bit of what Mr. Mosley said, the licensing authority is this board. We are very grateful that the staff has worked to get the folks in the system and get us started. But it seems like at some point, and I don't know if the rules should address this, but the board should ratify the actions of the staff that these folks are hereby. I mean, some boards actually interview folks and talk to them, like the contractors board, for example. They actually interview applicants, and y'all might have too many to do that, but at some point you would at least want to ratify the actions of the staff, it would seem like. And that sort of gets into, y'all also have the authority to sanction the regulated community. And again, I have a great deal of respect for the staff, but I think at some point before discipline is assessed and imposed, it would seem like the board would at least sign off and ratify that. And it seems like the rules would want to address that. I think just from a due process requirement. And then lastly, I hesitate to bring this up, but there's a statutory requirement for each person in the audience and online, anybody that's in the bail business, for continuing education. It's been a requirement for 30 years. They have to take up, just like lawyers, for the lawyers on the board, lawyers have to do 15 hours a year. Bail agents have to do 8 hours a year. I don't believe there's any mention in the application process of compliance with that statutory provision. And the rules might be able to gloss to fix that. I don't know. But then I guess lastly, in conclusion, just respectfully, ponder, and you don't have to decide right now, but just ponder tapping the brakes on the rulemaking process. There's been lots of comments, lots of questions, lots of implementation questions. We could do this at the next meeting, just thinking out loud with y'all. But to close, I'm grateful for y'all's willingness to serve and for the opportunity to speak to y'all. I don't have written comments today, but perhaps my time might be left open to submit written comments on the rules might be helpful. But with that, thank you for your time. I'm grateful for the opportunity.
Thank you, sir.
Brooke Marlin, I believe. Marlin, thank you.
Good morning, Board. My name is Brooke Harlan. I own Brooks Bell Bonding in Nashville, Tennessee, Davidson County. On behalf of my company and many others in Davidson County, I do have a few questions, concerns, and requested clarity from the board. Many of you have heard today the problems that we have experienced with the registration process. A lot of people have gone through the fingerprint process, and myself included, did not receive an email to confirm my time and date to go. Many other people have had those issues. We've gone, there's been documentation of notes on the door that their system is down. All of these issues, we were finally able to get that resolved this past week, but we still have not received our FBI or, through the Identico results back or acknowledged that that's even coming back. As of yesterday in Davidson County, there are approximately 20 bonding companies, and there's only been one successfully registered through the board. Our question and concern with many technology issues that we're having, will we be able to extend this unrealistic date of March the 1st? The next question is due process. The section under 4011-126, that we would let the board know that there have been arrests, whether that's a misdemeanor or a felony. I know that that was addressed a few minutes ago. However, with our profession, many of you know, our bail agents, we don't really have advocates out here advocating for us. So unfortunately, we go to do our job and we get arrested. I don't get arrested. I don't go out there, but many of my agents have been arrested and for simply doing their job. If we report this to the board and there's, a hearing and we don't have, I think there's a lot of questions and concerns around the due process of that. When would the date be that this hearing is? Are we automatically suspended without a due process? I would hope not. I mean, we'd be having a lot of time in federal court if that was the case, but that is a lot of the confusion about the due process of, if there is an arrest or a complaint filed. Sometimes there can be bonding companies that file complaints against other bonding companies. How are these heard? How are you, circumventing these and filtering these out? And if there are complaints, what is the process? Do we have representation like we would in court now? If somebody files a complaint against us or there's a show cause, we go to court, we have a hearing, we have our attorneys present. What is the process? There's just a lot of things that are very vague, and I think people just are expecting a little bit more understanding and clarity. There's many other questions that we have, but we'll hold those off till another time. Thank you.
Thank you.
The last name's Anderson, the last person on the Lethem. Come on up. Thank you. What was the first name?
Luther.
Luther. Thank you, sir. Oh, yours. Thank you.
Thanks for hearing me. I just got two questions about the FBI and TBI. The FBI kind of covers the whole 50 states. I think the TBI is kind of a waste of time for us to have to do that. You guys can look at your rules, and then I think the approval process for bonding companies, currently it says we have to get approved still through the court system, and then we have to do it here, but what order is it done? I mean, because if the court says, hey, are you approved by the state? We're going to say no, because the state says we can't get approved because we show our orders in order to be approved by the state. maybe we should think about just moving it all to the state and taking it away from the court. But that's really all I have. Thank you.
Mr. Williams, you wanted to sign up? We've got one more person. Will you sign up and then say your name?
Yes, ma'am. Good morning, distinguished board. How are you this morning? We appreciate your time and being here. As you can tell, we're all concerned about the new board and how things are going to happen. Obviously, anytime there is change, it draws fear and speculation of what might happen. So I just want to clarify one thing that I think someone tried to make a point the board might not understand it. These new rules obviously are based on other boards that the state monitor. One of those is the real estate board. And the real estate board, just as this board, charges the real estate broker a $250 fee to hang their license at the real estate office. Or if I want to work for Parks Real Estate, I have to go get my license to be a real estate agent, just as I do a bondsman. And then I have to pay the $250 to a board similar to this one, or, similar to a licensing board. However, the Parks Real Estate or whoever the real estate board is not required to pay that $100 fee to hang a license. They can put as many real estate agents as they want under their umbrella. It's the real estate agent's responsibility to pay for their licensing, and they are responsible for their own actions through their licensing. Under some of these new rules, for one, you're making the bondsman, as it's been stated before, I'm paying $500 to be approved as the company and with my credentials, and I was approved pretty quickly. I was very surprised at how quickly I was approved, my company. However, all of the same credentials was then uploaded to my personal account, and it's still been waiting for 5 days. And I understand that's not a lot considering the amount of work that Ms. Roxanne and her people have to do. However, my main point was to point out to the board that this extra $100 fee that everyone is concerned about is holding us to a higher standard than you even hold the real estate people that you've done for multiple years, that y'all have licensed, not this board, but the Tennessee's board. So that's one concern. It's minimal, but it is a concern. That was the main thing I wanted to point out. I think that wasn't clearly addressed earlier, was that a lot of the companies are concerned that we pay $500 to be approved as an agent, or the company, then the agent, then you have to pay $250 to hang your license on your wall, and then you have to pay $100 to hang your license on your wall. I think that there's some overlap there. That is what a lot of people are concerned about. Now, obviously, everyone is concerned about the fact that we're all paying much more than we've ever paid. And that's a concern. Anytime there's taxes added, everyone's going to be concerned. I'm not concerned with the taxes. I just wanted to point out that the fee, the $100 fee, does overlap multiple times when you are licensing the owner, or when the owner is adding a new agent and now they're responsible for paying a new fee, where other boards that are monitored by the state are not required to do the same. That $100 fee is not applicable. It's only applicable the $250 fee. So this holds us to a higher standard than the real estate board. That was my only suggestion, that the board look at, or that the board oversee. I haven't had a huge amount of problems, but I understand that everybody has. And I think a lot of that is just concern of something that's new, something that is still in the works. You guys know as well as all of us that this is going to be a learning curve for everyone. But feel free. Obviously, Miss Alexander was the president of our other board. She's very knowledgeable. Our attorneys have all offered, our lobbyists have all offered to help. Please reach out if the board has any questions that are outside their purview to any of us. Obviously, we're all here concerned. Hope we can get through all this together, and thank you for your time.
Thank you, Mr. Williams.
Thank you.
His name is Roscoe Williams.
Williams. Thank you. And we have, Ms. Denise Evans was not signed up, but she is going to go ahead and add herself. Go right ahead.
Hi, good afternoon. Thank you for serving on the board. First off, I'd like to say thank you to Roxanne and her staff. I have a large company. I've had numerous problems with the website, and every phone call I've made, her staff has been wonderful and assisted. I managed to get all 19 employees certified in a timely manner according to the law. My concern is, under our new code, I feel that this takes away the judges and the court's rights to determine if bonding companies and bonding agents can perform their duty in their district. So I've spoken with several clerks and several DAs, and they're a little confused. They feel like once we've got this license, we do not have to go through them anymore. Some of them are stating that we must have the license before we can get approved through them. So if this board and these rules, as I have read it and discussed it with several people, takes the rights from our courts and our judges, stating that the only thing that they can determine is if our company is solvent, then where do we proceed from here? That's a question a lot of companies have. Do I take my agents to every court in this district, present my license, and say we're here to write bonds in your jurisdiction? Or do I go through the process that we've had to do for numerous years, submitting all of our qualifications and being approved by our judges? That is my question.
There was one other gentleman that wanted to sign up. Go ahead and come up, please. You could sign up. And your name is on the record?
Amir Karshinas. Amir Karshinas.
Thank you, sir.
Thank you. Good morning, board. My name is Amir Karshinas with American Bonding, and I appreciate it for all of you to be here and allow us to be able to speak. One of my concern is, as my wife, she's in real estate for 35 years, maybe 40 years. And when I show her all these fees, she got upset at me and said, you still want to continue? These are so much high charges. And I'm in real estate. They don't charge us that much money. And this is one of the reasons most of us, this all fee add up. And we hope that what you guys doing help us to, as a professional people, to the state, be in the right track and do the right job, as most of us we are doing. And another thing is my wife also tried to get to the website a bunch of times, and we had so much problem. And I really did not know anything about all this new board that we have with the state. I found it through one of my colleagues. And yesterday, I guess I find out I had to go rush to TBI, do the fingerprint and this and that, so I would not be disqualified. But, we are here to help each other and make a state better than anywhere else. And you guys, as a board, we appreciated that you're going to help us and try to be reasonable on some of the fees and so on. Thank you very much. You have a good day.
Dana, I'm going to take a minute to see if anyone else has signed up through WebEx before turning it back to Ed.
Yes, I am unmuting Jason Holt.
Thank you. Mr. Holt, go right ahead.
Yes, thank you again for your time. As far as the website's concerned, they answered me back promptly. We followed through with everything. It seemed to be working okay. I want to thank them for that. Just to touch on what Mr. Williams spoke about a little bit, as far as the fees, the federal government and things notices a DBA, which would be classified as a professional bondsman, sole proprietorship as one and the same. So I would like just to throw that out there for maybe the board to keep that in mind. Again, why are we paying for the company and me as an agent when I am the company and the company is me? That's all I had. Thank you again for your time.
Thank you, sir. Dana, do we have any other chats?
No.
Okay, thank you. Alrighty. Sign it if you could. Thank you.
My name is Wayne Parker. I own First Stop Bonding. I was wondering about the non-refund policy on the fees. I don't have a problem with the fees that y'all are charging. I had some agents that changed their mind after I paid. In any industry I've dealt with, especially this one, if I don't perform the service, I ain't never been able to just keep somebody's money. If I paid out for 3 agents and they changed their mind at the last minute, I have to, y'all get to keep my money? I'm trying to understand how that works, because if I don't do the bond, I can't keep the money. Even when I pay the taxes, if I overpaid on taxes to $12, the state don't just keep it, they actually give me a credit. So I'm trying to understand why y'all are just saying that there's no refunds and we're just gonna keep your money if you make a mistake. Or even if let's say I bought a car and the car wrecked, and within 3 months of having it, y'all let me transfer, the state lets you transfer the title. So they don't, they don't just say you just chuck the car. If you can transfer the title, why can't I be able to at least put the money on another agent or something of that nature? But just, it seems like a little bit like a robbery to me. Like somebody just put a gun to my back and said, hey, I'm gonna just keep this money. I can't keep a person's money if I bond them out. And if I don't bond them out, I don't get to keep their money. I haven't performed the service. So I was just wondering about that little part. Just wanted to ask a question about that. Thank you for your time.
There, anyone else that did need to sign up and didn't get a chance to? Okay, seeing none, I'll turn it back over to you.
All right, perfectly. And just to kind of reiterate the procedures of today. So the purpose of the rulemaking is to solicit public comment. These public comments then are added to the filing form that is sent to the Joint Government Operations Committee and filed with the Secretary of State's office. There are responses that are added to those. And since there were many comments that kind of touched on the same thing, we thought it would be helpful to put some of these responses together based on topics instead of individual comments, just for efficiency. So to start with the first comment that was regarding reporting requirements, there were specific questions regarding the FBI, TBI background checks and misdemeanors. I did want to point everyone's attention to TCA 40-11-125 that specifically discusses if an individual is applying for a license and they have been convicted in this state or any other state of 2 or more misdemeanors equivalent to Tennessee Class A or Class B misdemeanors, provided however the misdemeanor conviction shall have occurred within the last 5 years. That is why we are looking at having those misdemeanors reported to the board because it's in statute that prohibits someone from having this license. Additionally, that is why it is looking at the FBI background check as well as the TBI background check, because these licenses or this license is not eligible for someone who has a felony in another state or misdemeanors in other states. And was noted by another commenter, the TBI background checks do not always pick up that information, which we have also seen when individuals have submitted applications, specifically only providing the TBI background check. And then when the FBI background check has been provided, they have not been eligible for this license. So that is why that is being requested, because by statute, these individuals are not eligible for the license. There have been discussions internally with making sure that there's more clarity on the statute, but that is a response to that specific comment. Again, with background checks, as has been noted and staff has been transparent with the industry, there have been issues with the ORI number. The staff is working the best they can through any changes that need to occur to make sure that an ORI number can be provided. And we appreciate the patience of the industry and the cooperation with all applicants. If you have questions about your background check or any issues, Ms. Gamusio has answered those questions. She's provided questions as well as to legal when legal needs to look at it. But if you have specific issues or specific questions, please reach out to Ms. Gamusio about those background checks. Our staff is working the best they can to process these applications. However, there are limitations where the FBI will not provide an ORI number for the federal background check due to the language in the statute. So that is something that we are looking at. As it relates to the website is available for applications. If you have any questions regarding submitting the application, technical issues, our staff is happy to walk through that process. We walk through application process with applicants on a daily basis, and we're happy to continue to do so, and apologize for any inconvenience that you are experiencing with the website. As it relates to fees, I think one commenter had noted how the fee is structured related to some other professions as well. The specific fee for companies was set at an amount with small businesses in mind. Rather than set one large fee, because this board does have to be self-sufficient and cover its costs based on the fees that are brought in, has to hold this program up, including all technology, staffing, investigations, all of those fees. The board can either look at setting one large fee that would apply to all licensees, regardless of if it's a company with one person or a company with 500 individuals. I don't think we have any companies with 500 individuals, but that is why that was proposed, was to make sure that businesses that may be smaller are not being assessed $2,000, $4,000 for a company license fee. Instead, they're paying $500 plus the $100 for any professional bondsmen that work for them. Our legal staff did a comparison with other states. For example, the company license fee in the state of Arkansas is $2,500 for the company and $200 for the individual. The decision to set it at $500 for the company plus $100 per individual was made with that in mind, to set it at a rate that will fairly impact the sizes of the business, so that smaller businesses are not paying a larger amount, and to set an amount that is equitable across the board. This is not necessarily a duplicative fee. I know that has been something that's been discussed. Again, we're looking at the size of the company and to make sure that that company license fee is fair across the board. So I apologize for any confusion with that. I know that may look a little bit strange, and we've had some comments about it being duplicative, but if a company, for example, has 3 owners, all of those individuals are also writing bonds, then yes, they would be charged that $100. Yes, they would also pay individual bondsman fees. However, if that company has only 1 owner who is writing bonds and 2 owners who are not actively engaged in bonding, then they would only pay that $100. They would not be paying for individual bonding fees as well. This is also a practice that the department has used with other licenses, in which companies pay a fee and then registered employees or other individuals under them help or pay their own fees as well. So specifically, the amount that was set within fee, the board has the authority to change that if they felt like it should be changed at this time. However, that was set after a comparison of our neighboring states and the rates at which companies are paying. Our rates are on average lower than what bondsmen are paying in our neighboring states, and we have set it at an amount that we believe is fair to small businesses. There was also a question related to DBAs. The board has actually addressed this with specific applicants. The company looks at, or the board looks, or the staff looks at the company as it's formed with the Secretary of State's office. Therefore, if a company is registered with multiple DBAs, they're only paying one company fee because it is only one company at that point. It's not 5 companies if they've got company plus 4 DBAs. So
But
that
what
is-
about sole proprietorship in that? Because I believe that a sole proprietor and a company, I believe the gentleman is on to something, and I'm a LLC, but he is the company and the company is he.
So if he is registered as a company under the definition, then he would be paying a company fee. But as it relates to a DBA, well, and I think that's part of if he wants to get rid of his company, he can do that. I can't hear you. I'm sorry, you're not.
I'm sorry, I'm talking to myself. I have
Okay.
to, I have to think while you're talking.
I
I'll speak
understand.
up if I want to talk.
I just want to make sure that I hear you and I'm not, talking over you. That is something that we'd have to look at, but if they meet the definition of a company and he is operating a company as well as operating as an individual, that is something we'd look at. We're happy to look at it. If he's really truly not a company, that is something that we can consider and work with him on.
So in that scenario, he would have to pay the $250 application fee and like, let's say it was John Smith and it was just John Smith and there's no LLC, there's no nothing. And he would just have to pay $100 for him as a professional bondsman, or he would also have to pay the $500.
So if he is truly just operating as his own, if he's just a bondsman, then I suppose he would not be paying a company license at that point. Because he's associated with the company. I'm sorry. So he'd be paying the company fee if he is operating that company, and then he's paying that bondsman fee.
And the $100.
So he would still have to pay the 500 and the 100.
That's correct.
Thank you.
I need to make sure that you're on the record. If you are making a
Okay,
comment.
so my understanding is he would pay 500 for his company, 100 to have him listed as an agent, and then the 250 to get his own license to post bail. Correct? Is that correct? So it cost him $850 to go be able to post a bond on this fee schedule.
That's the way I read it, yeah.
I think that's correct. We're happy to look at that with individuals as well to make sure we're fairly, looking at their fees with them.
Thank you.
The next item that I had was the CE. There was a request about CE. Continuing education is already listed in the statute. It was not added to these rules at this time. And I think Mr. Williams had mentioned this at the beginning, but these rules were really established to kind of take everything off and to, make sure that this board can start operating. There was another comment regarding the enactment dates. That March 1st date is set in statute. So, that's set in law. We can't change that with the rules in terms of when these licensing requirements take effect. So we were cognizant of that with making sure that we did not set too many rules in here to make too much confusion. We really wanted to look at the bare bones of what are needed to get everything going, to set all rules in place by March 1st. There's not a delay there. So that is why continuing education is not addressed, since it's already set in statute and is not something that most bondsmen will have to necessarily look at within the next year or so. That's something that we would like for the board to look at a later date. There was.
What do you mean? What do you mean by that? Look at what at a later date?
Oh, I'm sorry. If there are any procedures that need to be added for continuing education to be added by rule, that we could look at that at a later date, but that's not something that would be necessary to start this program day one.
And that is because it's already in TCA code, correct?
Correct.
Okay, making sure I understand. I'm a nerd.
No, you're fine. I appreciate it. Okay.
I just would like to clarify one thing. Sorry. That good? Okay, I'd just like to clarify one thing. You shouldn't have any owners that are not listed as agents for their company. I know that you said in case they didn't, but by statute, every bondsman has to have 2 years experience and has to have continuing education every year. Currently, that's done through an association. That may change this year with statute. We don't know yet. However, currently, But I just want to make sure that you understand that everyone, even the owner, does have to list themselves as an agent in every company because you have to have 2 years experience and a continuing education. So every owner will have to be listed as an agent. There shouldn't be any instances where an owner, and I'm on the board of professional bondsmen as far as the association. And I've had a lot of calls about people going, well, they said I didn't have to register as an agent if I didn't want to, so I don't have to pay the $350 for myself. And I just want to clarify that's not correct. Everyone has to list. If you don't want to write bonds, that's fine. However, you still have to be a bonding agent to own the company by statute. So I just want to clarify that for the board because it seemed to be confusion. And as Judge Turner knows, I'm a sole proprietor myself. I understand the law, the fees are the fees. You have to be able to fund the board. But I just wanted to point out that you shouldn't have an incident where a DBA is, he still has to have a business license. And if it's for instance, an LLC, and Miss Shelley spends a lot more time dealing with things other than actually going to the jail, she still has to maintain a bail bonding license to be able to own and operate the company. So I just want to clarify that in case you weren't aware of that statute.
Thank you.
That was all. Thank you very much.
I
I
appreciate
do have
that.
another comment on the chat too, whenever you're ready.
We're going to let Jesse finish. Thank you, Dana, and then I'll make sure to come back. Thank you.
So there are two comments regarding definitions, one regarding bonding company versus bondsman company. I think that is something that if the board wants to change that, I think you could do that by motion.
I'll make a motion
Okay.
that we change in number 3, bondsman to bonding, please.
And just for clarification, well, we would also need to change that throughout the rules where.
Throughout
bondsman
the
come-
rules, yes,
Perfect.
please.
Thank you.
I'll second.
Was that Anthony
Yes.
Kirkland second? Thank you. We have a motion by Shelley Alexander, second by Anthony Kirkland, to change the word as it's presented in, I think, a few places, correct, Jesse? From
Yes.
bondsman for the company to bonding company. Thank you. All those in favor, please say aye.
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 Any opposed? Thank you, Jesse. I think you're set.
I also have another motion I would like to make on every professional bondsman and professional bondsman company as far as reporting of arrest. As the owner, I've had multiple agents go rogue. If they're not gonna tell me, they're sure not gonna tell the state. So I would make a motion to remove and professional bonding company from number 1.
Where specifically are you referring to?
Number 5 on page 5, number 1, because the company may not know if an agent gets arrested. And I don't want my feet held to the fire if I have an agent going rogue.
So. Yes, so that is, I believe that is required by TCA. So one moment before we.
We'll need to look because it does say bondsman, not bondsman company, as I was just looking it up. It does.
So I believe that definition of bondsman includes company when you look at the definition in statute. So I think that was part of the reason that was included this way. 2, we have this requirement with other programs as well. And I know that we've talked a lot about other programs. And I don't know, just let
I
me
make
finish.
my motion. I'd like to stand on it.
Okay, well, I just want to clarify as well before we get there. So the reason that we have this for other programs, and I think that if you were to modify this, I might have a suggestion if you would entertain me. Part of the requirement is, someone might get arrested in another state, right? That bondsman doesn't tell us. If they tell the company and that company doesn't want to tell us, that company wants to continue to allow that individual to operate, that is something that would, I think, concern the company. I know that there was a comment about a criminal case, which is very different than putting this in rule. I think that if we were to modify this rule, I think my suggestion, if you will entertain me on this, would be, let me go back to 5 real fast. Would be to say any known arrest or citation, and to make it more of the company, because I understand your sentiment about if they don't tell you, you don't know, you don't want to be held to that standard. I think if we make it a requirement that if the company knows of the arrest, that they should have to report it to the board at that point, because if they do not know of it, I don't think that in reality that there would be a disciplinary action for something that is unknown.
I want to
But-
reach a little bit further. Joel, could you stand and help me explain this, please? Because you brought case law and I need to,
And this is a criminal case, though. This is different than the board's.
it was about
authority.
bonding.
With all due respect, in Ray Cumberland bail bonds is not a criminal case, though it does come out of the Court of Criminal Appeals. It is a civil case, as all bonding company matters are.
Okay.
And in that case, the statute was parsed very carefully by that court. And the court said that the obligation was on the bondsman, not the bonding company. That was separate. So even though the definition of professional bondsman does include the company itself, the obligation, because the definition didn't change, the obligation is on the agent, because the agent has an independent license under this scheme
That's right.
and an independent responsibility to report.
Mhm.
So trying to monitor a company's knowledge and investigate a company's knowledge seems to me to be kind of a dog chasing its tail, when in actuality, the malfeasance is on the agent. The agent reports or doesn't report. If the agent doesn't report and they have an arrest either inside the state of Tennessee or outside the state of Tennessee, they've committed a wrongdoing, not just under the regulation, but under the statute. And they need to be punished for that. But under the statute, the company doesn't perform a wrongdoing. While under the regulation, you're saying they do.
So respectfully, the board would have authority to set this as a ground to discipline a company. So that is where it is separate than that case, and the board would be authorized to promulgate this rule.
Well,
I do think that it would make sense, is the recommendation to the board. Again, you can make a motion to either strike it or keep it the same or modify it. My recommendation from our perspective would be, from a compliance standpoint, that if this were to be modified, put it under a knowing requirement. As I'll touch on with another comment regarding due process, there are specific requirements of due process that go into these administrative hearings. And I think that it is unlikely that the board would discipline someone who they did not have evidence, because the state would have to meet the burden on that. The board would have to decide. So I'll touch on due process in a minute. But I do think that if the board was aware of a company where the company knew that they had someone with a felony who did not report that arrest, they knew the bondsman did not report that arrest, and there's no requirement for the company to report that arrest, and the company said, well, that's the bondsman's obligation, that's not us as a licensee, I think that is something for the board to consider. That is, again, your decision, board. If you would like to have a motion and vote to remove that, you can do that. You can keep it as is, or you could modify it to make it a requirement that they need to report any known arrests or citations. Again, this would have to come down to the board would be the one making the decision if they felt like the board knew that this company was in violation of it. I'll touch on due process with the next comments, but that is the recommendation from legal counsel to the board.
I agree. Every agent has to have their own independent license as well. So I'm going to stand on, I make a motion to remove "and professional bondsman company" from 1A.
Question for the council. If the company,
Your mic's not on. Thank you.
if the company was aware that an agent had an issue and they didn't report it, if we strike this out, can we have any, can we take any action against the company if we strike this out?
No, sir. I don't see where the board would be able to discipline that company.
We have a motion. Is there a second?
Second.
Any discussion?
Record, I apologize, Mr. Kirkland.
Further discussion?
It ain't. Oh,
I second the motion.
Judge, back to you. Thank you.
Discussion on the motion, anybody? on this issue, I want to remind the members, when we had our orientation, that the purpose of this board and the purpose of the Department of Commerce and Insurance is to protect the consumer. So the rules here are intended to protect consumers, and I'm not alleging anything against anyone here today, but from a company that may be acting illegally, unethically, because the companies that are licensed under this board are dealing with people that are likely at their lowest point in their life. I've never been arrested, but I can imagine that that is not a happy experience. And that those individuals are in desperate need to get a hold of somebody so that they can defend themselves in court, they can join their family. And I just wanted to remind the board of the purpose of this board. Thank you.
Thank you very much, Chairman. We have a motion by Shelley Alexander. We have a second by Anthony Kirkland. All those in favor of striking this from the rule as the rules presented, please say aye. I'm going to do roll call vote to make sure that I've got this correct. You'll bear with me. And the call is to have this taken off the record, not modified as legal counsel had suggested. James Turner?
No.
Thank you. Russell Baker?
No.
Thank you. General Thompson?
No.
Thank you. Rex Lynch? Thank you. Shelley Alexander?
Yes.
Thank you. Anthony Kirkland? Thank you. And Kyle Turner? We have 4 noes and 3 yeses. Therefore, this is not being stricken off the rules as presented. Jesse, I'll turn it back.
I would like to revise that. I make a motion, we change it to known.
Second.
Any discussion? All in favor, say aye.
Aye.
All opposed? Motion carries.
All right, thank you. Well, I think jumping to due process. I think jumping to due process might be helpful because this kind of goes back to that whole issue. So the board is, charged with the ability to discipline a licensee. I know we've discussed during the emergency rules, the civil penalties, that the statute has allowed the board to assess civil penalties as well as to revoke or suspend a license of a bonding agent or bonding company. Under the UAPA, there are certain provisions that have to be in place. Individuals are provided notice, they're provided an opportunity for a hearing. Certainly, they can have an attorney represent them in those hearings. And actually, if they're a company, they are required to have an attorney. You can't represent a company because it would be unauthorized practice of law if you own a company and you show up as the owner to try to represent it. That's not anything that we've said, that's law, because you're trying to represent another individual. So there are requirements under that as it relates to, if the board finds that someone committed a violation, they are brought before, the board hears all the evidence and makes a decision. There are certain other times in which law may allow for the suspension of a license if certain requirements are not met. However, generally, due process under the UAPA is under all of our hearings. I'm just wanting to give some other examples because there are summary suspension actions. If there's an immediate risk of harm, the board can usually revoke or suspend a license indefinitely as before an individual has a hearing. And I think and there is another provision regarding if an individual doesn't report a felony arrest to the court or to the board regarding a suspension of that individual's bonding privileges and license. So And that's in TCA, so that is where it's a little bit different. But just in general, if we go back to the, if a company doesn't report an individual who's been arrested, that type of hearing would have to go through a UAPA hearing. The board would ultimately be the body that makes that decision. It's not an administrative law judge. It's not me. It's not Ms. Gamusio. It's not Mr. Williams. The board would be the one who would decide, should this person's license be suspended, revoked, or a penalty assessed, or should it be dismissed? That's also within the board's authority. So I did want to go through, there's been a lot of questions about due process. There's a whole body of law under the UAPA. If anyone has specific questions, I'm happy to point them to those citations as well.
I would like to have those because this industry runs or is always ran off notification on a lot of things. So like if someone misses court, then we have to be notified on a final forfeiture by certified mail. So how would a bonding company get notified if there was a complaint or an issue? But just because I don't know.
So some of that's, not specifically addressed in the rule because that's a little bit how the department operates. We have a whole platform. And in fact, I've already received complaints against bondsmen. This is already set up on our website. So if anyone wants to file a complaint, they can go to the website. There's a tab that says file a complaint. Typically, that complaint, once it's received, is sent directly to the respondent, the party the complaint is made against. That individual has the opportunity to respond to that complaint. If we don't receive a response within 14 days, we typically remind them, hey, we have not received a response from you. After that is, if they make a response, they don't make a response, we look at it a little bit differently. If there is a violation, we have some internal standards that our attorneys operate off of about conducting investigations. Certainly if it's a situation, just to give an example, but if we got a complaint that says this bondsman, I'll use my own name, Jesse Gentry is arrested for a felony in Rutherford County, that would be something that our attorney could easily, if they don't make a response to that, call Rutherford County and get record of that from the court. We have investigators on staff as well. If there was an issue where, maybe there was a conduct violation, we need to get witness statements, we need to interview individuals, our investigators can actually do that for us. So we can build that case. Then we would present that to the board with our findings. Complaints that will be presented to the board, we haven't done this yet because you all haven't had a meeting where we do that, but those are actually presented anonymously. We present those to our boards in an anonymous manner, so there's no impropriety. Typically, if you're a bondsman and you are on a board and there's a complaint against your company, you would know the complaint number. We'd expect that person to recuse themselves. But ultimately those are presented in an anonymous way. The board then makes a determination if it should go to a formal hearing, if it should be closed. Typically our boards, when they decide if it should go to a formal hearing, also make a settlement offer at that time. So when we start getting complaints, we will walk through the board through that process. We would kind of default to our internal procedures for setting that up. And then certainly, when the board wants to start hearing cases, we'll talk about making sure that those get set. But if you need the citation to the UAPA, it is in Title 4, Section 5, Chapter 5, Part 3 for contested cases.
Title 4, Section, just because I like to know, Section 5.
Part 3.
Thank you.
And in that complaint website, there's a requirement that the license number. Is that correct?
Typically, I will say from experience with other programs, if we can figure out, if a consumer, for example, doesn't have that information, sometimes we'll contact that complainant to see what other information we can get to tie it to the correct entity. Because sometimes, people will use in Tennessee, they'll use the name volunteer for their company, volunteer builders, volunteer construction. If they file a complaint and we want to make sure that we're tying that to the right company, the bonding company, if we have Mike's Bonding in Shelby County and Michael's Bonding in East Tennessee, we want to make sure we're using the correct bonding company to tie that to. So we do follow up with complainants. So that way some companies says, I have no idea why is this on my record. If that answers your question, I apologize if that.
Jesse, are you okay taking a question regarding something you stated from someone right now, or you want to go ahead and go to the end?
Is it a question regarding complaints?
It's a follow-up question.
I need you on the record.
I'm
Don't
sorry.
mind.
Sure.
That's okay. Your name, please.
Kristen Croissant. Did I understand you correctly to say that you're going to reach out to the agent if there's a complaint against them, not the company?
So,
When will the company find out?
so that's a good question. So if the complaint was made against the company, we would send it to the company. If
Okay.
it was made against the agent, it would go to the agent.
So when does the company find out that there was a complaint against the agent?
So I don't think we have it set up right now that it would go to the tied company. If that's something that the board would want or the industry would also like, I would recommend that we look at that at a separate rulemaking to put that procedure in place, if that is something that would be appropriate.
Well, aren't we being held, can't we be fined also if there's something, if our agent did something wrong, can't the company be held financially responsible as well?
So
shouldn't we be notified?
if the board was going to take action against the company, would have to open a separate complaint against the company and notify them at that time. Does that help explain it?
Not really, but I guess it's okay.
I have a follow-up question. Can I address? Sorry. I know this is killing you and I'm sorry. Thank you,
Your
Mr.
mic.
Gentry, for your patience.
Your mic.
My only issue with this is that and I don't mean any disrespect, you're playing both sides of this card. On one side, you say, no, if I know, which I don't know how the court's ever going to determine what I know and don't know, unless I bonded the person out and didn't notify. Now, that would be different, but if they were in another state or something. But on one side, you're saying that you're going to charge the company if they knew. And on the other hand, you say that if you find out that my agent done something that he's not supposed to do, you're going to address it with an agent. He's not your employee, he's mine. I understand you should address it with him, but I do feel like if I had to pay $100 to hang his license to you, then you should also notify the company he is attached to that, hey, we have a complaint against your agent. I feel like that there should be, you can't be on both sides of that fence. And I don't mean that disrespectful, but I would like to see you add something in there where if my agent is charged with any complaint, the company should be notified, because I need to know if my client, and I would be the first one to show here. I had a family member that worked for me that got a DUI one night, and the very next Monday morning, I suspended her myself. I understand everybody don't do that, but I run a company with integrity, and I understand you don't, and that's probably why this board is here, because there's a lot of companies that don't. That's the necessary for this board. But I would like to see language that said it. So just like the gentleman said earlier, when I paid for agents as well that backed out of doing this, and now I've spent $1,100 and I have 3 agents instead of 6. But with that being said, if you're going to say we're charging you to put this person's license on the board, you should also say we're going to notify you if we get a complaint on your agent. I understand it should be, anonymous, but I believe that it should definitely go to me being my employee.
I appreciate that. And I think that is just for the boards and everyone's awareness. I think that would have to come through a separate rulemaking, since based on what's noticed in this, I don't think that we could add it to the specific rules, since it's kind of a bigger amendment. But if that is something the board would like to entertain after this rulemaking, if there's any other rules, any other items that we think should be added, we would ask the board to authorize Mr. Williams to start that process. And I appreciate, I didn't take that comment disrespectfully at all. Genuinely appreciate it. It's just not how our system is set up. So if we need to do that for this specific industry, I think we can do that.
I just feel like that, I mean, we are, as Judge Turner, I apologize, mentioned, we are dealing with people that are at their lowest form of life. And a lot of times in this industry, we have to maintain a clear criminal record. And obviously, if someone was arrested and they're fixing to lose their livelihood, then they're going to be very unlikely to tell the owner of that company or the state if they don't have to. I don't say that's right. It's absolutely wrong. But I believe that if you're going to hold our feet to the fire, then your feet should be held to the fire to notify us if you're aware of it as well. That's all I'm asking, is transparency back and forth. Thank you very much for your time again. I apologize for having so many questions.
We appreciate it. We appreciate your comments. So I've got a couple more. I don't know if the board needs to take a break at any point, but I've got a couple through to get through if that works. Are you all good?
Let's
Okay.
keep going.
Perfect. There was a comment about approval process as well as it related to the board's definition of the board being the board or the board's designee. We did specifically set a rule talking about the executive director being able to approve certain applications, to be able to delegate that. Typically, the statutes look at, if the board being able to approve things, the board can delegate that to the executive director. We do that with other boards as well. Typically, we didn't add too many applications. Obviously, we didn't say all applications because there are certain things that we will want to take before the board for the board to make a decision if someone's license should be reviewed. We did put it in the emergency rules because we felt like it was the most efficient way based on our timelines was to allow Ms. Camusio to be able to approve as many as possible. I don't think that there's any need to amend the rules if the board feels like they need to amend the rules related to Ms. Camusio or the executive director being able to approve certain applications. We can look at that. There was a comment about judges being able to determine authority in their district. Most of this, it mirrors the statute, and the statute is a little bit different as it relates to licensing of professions where the judges have authority within their jurisdictions. I will say as it relates to, and this is something that if anyone has specific questions, judges, if clerks have questions, we are more than happy to communicate with those individual agency or authorities as well, because we want to make sure that we're all on the same page. We have communicated previously. Mr. Williams did an excellent job of getting a list of every court clerk and reaching out to them initially about questions and comments, getting lists from them. So we do want to make sure that if we are, having questions there from the local jurisdictions, that we can answer those. There is still authority in statute by judges to determine who can post bond within their jurisdictions. That was not removed and is not removed by these rules. It's not removed by the statutes creating the license. They would need to have a license. That is kind of the only other issue is that, and that's the issue is if a judge says, I want this person to be able to post in my jurisdiction, but the board has denied that license application, say the person has a felony, that's going to create a little bit of a disconnect. That is something that we will have to work on with that local jurisdiction. However, there shouldn't really be issues at this point between who licenses first or doesn't license first. We do ask on the application where the individuals are approved. We have followed up with those local jurisdictions as well to make sure that individuals who have questions, if they've been suspended in those jurisdictions, we do ask that information from them. But if there are questions by judges or clerks, we'd be happy to deal with them. And encourage bonding agents as well to tell us if they're having issues with a specific judge or clerk. We can proactively reach out as well. And I think the last item that I had, kind of grouping these all together, was about fees being non-refundable. So we typically put that in all of our rules. This is, again, if the board wants to strike that, they could. The reason we put that in all of our rules is because when the individual goes through that process to submit the application, we've already invested that cost in the technology fee. Typically, we've had staff look at it. There are situations, obviously, where someone submits an application by accident, and we have worked with individuals on that case to try to issue refunds where appropriate. But typically, we haven't had an issue where it's an individual who is asking for a refund, or after everything has kind of already been reviewed by our staff. So that is why we include that in there, because we just, if we've denied somebody, and then someone says, well, I want a refund now at this point, it puts us in a weird spot because we've already invested the cost. If the board wants to look at that, they could discuss modifying that, but that's why that language was included.
My personal opinion, I wouldn't have a problem with refunding the money. I think, back, I'll tell you, a couple years ago, when we started the process, we were starting this process. I had a couple of bonding companies come in and we were getting ahead of the game. They applied the process. We were doing the background check. They submitted some money in and we stopped it. I refunded their money. I mean, I had some time and money invested in it, and I didn't have a bit of problem to refund their money. So I wouldn't have an issue with changing that. And I'd like to see to refund the money. We've got enough money that these bonding companies are investing in it. So my motion would be to change it to allow to refund the money.
I'll second.
Any discussion? My question is, what is the timeline on the refund? I mean, is there is it? I mean,
You could make a modification to the rule to say the application fee is only refundable within the first 30 days of submission, or for 14 days of submission if the applicant requests it and there has not been a decision made. Because I think that would be the issue, is that if someone submits the application and they're denied because of, some type of.
Within 30 days of submittal.
Okay.
would you be willing to amend your motion?
Yes.
I need you on the record.
Yes, within 30 days of submittal.
And is that fine with the second?
It stands.
Any further discussion? All in favor, say aye.
Aye.
All opposed? Ayes have it. And
Yes,
that
Mr.
relates to 03 3. I guess. I guess all of those 2 and 3.
And it would have 5 as well. Roar and change of information. There's.
Okay.
We'll take care of that. We'll make sure that that's addressed.
I
That
have
was.
a- I have something I want to ask. So you said when going over these fees, and I'm only asking this because I just read it. So it cost 500 for the company, 250 for the owner, 250 per agent, $100 to have an agent on with your company. But then if I decide, if a company goes to remove an agent, even if it's because they caught charges, it would cost them an additional $100 to remove them. And that is page 5, last paragraph.
I just read that. He's going to add this. I think it's only to add.
And we haven't got that set up yet. I do need to clarify the refund.
So does that relate to any change of any bonding agent, whether, I guess,
So that should be for adding an agent. I know we haven't set that up in the system yet. It does read as if it would be for adding or removing though, but it should only be for adding. So if you wanted to amend that.
so it could say that after that period of $100 application fee, this fee shall not apply to a bonding company removing an agent. I mean, it's called an application fee. You wouldn't be applying to remove someone.
Right, exactly.
But I mean, we could add that in there.
Or we could put application fee to add a bondsman. Or to add.
To their agent list.
Yes, to add bondsman to their agent list. Because that's not the intent, was that if you suspend someone, and it's not the way that, so I understand your concern.
So I would like to amend that to say application fee for adding a bondsman.
Correct.
Is there a second?
Second.
Discussion? Hearing none. All in favor, say aye.
Aye.
All opposed? Ayes have it.
And that was all of the comments that I had kind of grouped together based on subject. I know that there were a lot of comments specifically about the website or individual issues with applications. Again, we apologize for any inconvenience and appreciate the cooperation of everyone who's making applications. Ms. Camusio and her staff are happy to walk through that process with everyone. So I think she has her card. If not, we can provide her contact information to make sure that you all are in contact. As I said, really the comment about the enactment dates, that March date is set by statute. So if there's anything, that we can help with, we've talked through background checks. I know with bondsmen, I've had questions on that. We've walked through people with getting those completed, getting applications completed. So, we are happy to make those, make that assistance.
I have a question as far as that goes. So effective March the 1st,
March 11th or first?
It's first.
it's the 1st, March 1st. How are our clerks and sheriffs, does everyone know that this is the new law? Because I've had a couple that did not know, and I've had to reach out. Y'all quit looking at me. I'm tired.
I mean, we have reached out to the court clerk, so we are happy to reach out to them again if that's something the
And
board
I
would
think
like.
the sheriffs need to know, because let's say a bond is written at 1 o'clock in the morning. The clerk normally is not there. Are you, Rex?
No.
We know how to get a hold of Rex.
We can track him down. But I mean, wouldn't you say there's gonna be sheriffs that are really fixing to experience a lot of growing pains? They really are, and I'm more concerned about the sheriffs and our jails really than anything. I've thought long and hard on that. But it's here. I mean, so I don't know.
We would like some clarification on the courts having jurisdiction, still
Your name
keeping,
again?
Denise Evans,
Denise, thank you.
keeping jurisdiction. In order to do that, some of our courts are requiring the license prior to submitting to the courts to make sure they're approved. Is that going to be amended?
I can answer that,
Okay.
if you're okay with it. We've done it already. I've had new hires where the companies has refused to hire them until they got licensed. I have approved them without the judicial approval. I have approved them without those documents. They're blank fields that they'll need to follow up and send us once their court approves them and once they're hired. But we can't keep someone from being hired on a job when this license that is, new is holding them back. So it's going both ways. Same thing with those that are already active. Some judges and courts have said, until we see the license, we're not gonna let you continue bonding. So we've already done that. Does that
And
help?
there was a question from somebody online that didn't get on. They want to know how this board's going to deal with frivolous complaints from bondsmen who tend to complain unnecessarily.
I think Mr. Gentry kind of addressed that.
Yeah.
A lot of those types of things are dealt with internally. And, I don't think the board's in a position to prejudge any complaint before it, but I would feel comfortable in saying that if the proof that was presented to this board amounted to something frivolous, then I would imagine that we would dismiss the complaint. But I mean, again, we can't prejudge a complaint that we haven't seen. So,
Thank you. That was somebody online that didn't
Thank
get
you.
the answer. Thank you.
So I think that addresses the risk.
I just got one final question. I think this is what everybody actually came here for today. What is going to happen as of March 1st for all the people that are not? Are the courts going to suspend their capacity to write or their ability to write bonds until they're approved? Or what happens after Monday for everyone who has not been approved, whether you're in the approval process or whether you have not filed? Bonding companies that have not even filed yet. I know there are some in my district that have not even done their fingerprints yet or made any effort. So are they going to be suspended March 1st? People that are already in the application process? But obviously, Miss Roxana's office is working around the clock and they're still overlogged. You have close to 1,600 bondsmen, and I think you said 500 companies in this state. Come Monday, what happens? Because a lot of us are worried we're going to get to the jail and find out, hey, you haven't been approved. You're off the list now. And that's before a hearing, before any due process. So what happens then? Are you going to suspend me Monday, Jimmy? I'm sorry, Judge. Sorry, Judge. So, sorry.
I just want to make this comment on that.
Yes, sir.
There have been 454 companies that have applied. 70% have been approved, and let's say hypothetically all 454 were approved by Monday or March 1st. And we had another 1,000 out there that hadn't. How fair is it to that 454 that actually went through the trouble when the other 1,000 didn't? How is the judicial conference, the General Sessions Judges Conference, how is this board supposed to have any, first of all, follow the law? I understand there's a lot of people that don't agree with it. This is not the body to complain about the statute, with all due respect. That is the General Assembly. But, in order for this board and the judges that administer the law of this state for anything that we do to have any value, it would be to suspend those companies. I'm not saying that, and I'm the presiding judge of the 16th Judicial District. I'm not saying that's what, I'm not making action today. Don't worry about it. But I just want to make that comment that we're doing a lot of nothing if we're not in a position to enforce the law in this body and the judges.
So would that mean, Your
Otherwise, we're
Honor,
just wasting our time. All the fees that have been paid by the people that have applied meant nothing. And so I don't think it's fair if I think someone said that they've got, all of their agents have been approved. How are we to look at that person in the eyes and say, thanks, but we're not going to enforce it for everybody else? And that's really a question for the presiding judge of each district, not this body.
but with this body having the right to address licensing issues, I guess, and I think one of the other people might have said that their courts, I personally already sent the court clerk of my district, of all 4 districts I write bonds in, my company approval letter, so they are aware that my company has been approved. I guess my question is, with due process and so forth, like you said, in the event that I'm not correctly licensed or I'm not correctly, despite doing anything wrong, just we'll say if the company can't, is this body going to suspend someone and then file a hearing, or will you be filing for a motion to remove their licensure or to suspend them or to fine them, and then they're still allowed to write bonds until that next hearing here in front of you guys happen? That's my question. Like if my company gets suspended or my company gets brought up to come here and account for actions, are we suspended until that hearing? Or we, which happens once a quarter, or is it going to be you're still allowed to function until you're proven guilty?
I think
I'm just
Mr.
trying to get
Gentry
sure.
addressed. So go ahead.
I'm sorry, Your Honor. I'm just
No,
unsure.
I think Mr. Gentry addressed that this body would only suspend somebody if, I can't remember the phrasing you used.
The only time, there are very few times where a company could be suspended without due process. There's a law regarding summary suspensions for any type of license, and the board would still have to make that decision. The board would have to meet to determine that an immediate risk to public safety, health, or welfare requires that immediate action. But I think that this question also doesn't really fit the statute, because the board can't suspend a license that's not been issued. So all these people who are not licensed, the board can't suspend their privileges. That's the individual, as Judge Turner noted, that's the individual court's decision. So let me finish. This board could fine those companies. They could find that if there was a company that was operating for months, say they're operating into April or May, this board could set a civil penalty against them. But if there's no license to suspend, the board can't suspend a license. That individual court, when we talked about the different jurisdictions here, that individual judicial district could suspend their bonding privileges within that specific county. But the board can only suspend or revoke a license that's been issued. So if your license has been issued, the board would only be able to suspend it if there's some type of violation by your company.
So is that to say that come Monday morning, anyone that doesn't have a license to hand over to their court for each company or for their company and each agent they have, is their company going to be suspended in their district? Because that would be at the judge's.
That would be a decision for the judge. That's not something the board could do.
Yeah, that's just my question is, what do we do Monday? Because I understand that everyone should have been working on this as diligently as possible. I know that I have. I'm not one to wait around when there's something needed to be done. However, I spoke with Roxanne when I got here. I helped someone get their license yesterday. They're already approved this morning, and mine has been pending for 5 days and hasn't been approved. And I literally turned in the same documents as my company. Now, I understand you guys have a huge job above you, and I'm not saying that I should take, but but it's no rhyme or reason. That was why my question came about, because I know that the documents that I turned in for me as an agent are the same documents turned in for me as a company. I literally just, copied the same ones because it had my approval from the 16th Judicial as among others. I'm just curious about if someone is, what happens Monday when people that are either in the application process or at least have made these efforts and are still waiting for the state to catch up on this mass amount of work that needs to be done to transform this. I know a lot of people are worried if they're going to be able to write a bond come Monday, and a lot of them understood that, or was under this understanding that it would be at this board's discretion. Obviously, you can't change the date, but that's what we've all been worried about. And that was my only question. Thank you so much. I'm sorry again.
Sorry. I'm
Mr.
Joe
Morrissey.
Morrissey. Good morning, Judge, committee, people. I represent a majority of bonding companies in Nashville, along with Mr. Mosley and a bunch of other people. And there is a concern and a growing concern amongst them about how many are unlicensed at this point, even though application process has begun. Now, I know there's been a lot of discussion. You can't suspend a license that hasn't been issued. That's going to be at the judge's discretion, but there are civil penalties attached to that. The question or the suggestion that I might put forth is that all the companies that have begun the process and that are waiting all of this information to come through to the courts, they be granted some clemency as it relates to any civil penalties y'all might be considering in some way, if any at all. That's one of the concessions that I have, because if Nashville goes without the 30-plus bondsmen, and I know that only one or two bonding companies have actually gotten their information sent to the court clerk's office, which is a concern that I know our clerk is watching right now and has a million questions that they have. One of the specific ones that they wanted me to make sure that we had addressed up here was, it says in the public chapter 491 that the department is going to provide the clerk's offices and the sheriffs with these lists. Davidson County has no list at this point. They do not know who has been approved and who has not been approved. And there is a growing concern amongst all individuals on Monday or over the weekend as this law changes, what is going to happen? Is the Davidson County Jail going to overflow because all of these fine people out here that write in Davidson County are not allowed to go write a bond because there is not a list that's hanging at the Davidson County Sheriff's Office, a duplicative list of all these companies that have been approved to write, or not? Now, I understand if we're saying in this meeting that it's going to be at the discretion of the sitting judges as to how that is handled, then that information is not going to happen, because I don't think there's going to be a judges meeting on a Friday afternoon here in Nashville. So they're all a lot of worried individuals behind me about that. And I think that, we talk about people trying to do the right thing. I think everybody who's here is trying to do the right thing. They're concerned because this is their livelihood and this is a profession that they love. So my suggestion, after speaking with all of my colleagues out here, would be if they've started this process, and I understand, Judge, what you're saying is that the people who haven't bothered to pick up a pen or a crayon or whatever it is and start this process, they shouldn't be given any sort of help. But all of these fine individuals have. And for better or for worse, it's very hard starting something new. And I do not envy the job that you guys have. When I learned about professional bail bondsman from Mr. J. Norman, he did not envy the task that he assigned to me to learn. So I do not envy what you have to do. But I would say that most of the people that are here, or if not all of the people here, have begun the process. Some are very successful and verbose, like the man before me. And then there are other people who haven't done anything. And if they haven't started the application process by today, perhaps they're not granted the same grace that the rest of the companies behind me are granted. So they just want to make sure that they're not going to get in trouble with this body, because they're going to continue to do their jobs and do right by the citizens of Davidson County and Nashville, Tennessee, by making sure that they don't stay in jail a moment longer than they have to and securing their constitutional rights. So that's that concern. So thank you so much for letting me be up here. Thank you for this wonderful hearing we've had. I hope I've addressed our clerk's one question that he emailed me, because I'd forever be in shame if I did not. So thank you all.
If I could just jump in real quick, Reed Wisher with the department. We are still going through the rulemaking process. There's specific procedures that are outlined that we must follow for the rulemaking process. We're now in the point in the rulemaking where we're summarizing responses to comments, and then there's additional rulemaking activity that we have to conduct. There is a public comment period at the conclusion of this meeting. We have provided the folks attending an opportunity to comment on the rules. There'll be another opportunity for public comment at the conclusion of the meeting. So I would ask that those in attendance allow us to conclude the rulemaking hearing, to continue to work through this board meeting, and there will be an opportunity for public comment at the end. Thank you.
At this point, then, the comment period has concluded. It appears that everyone wants to ask a question in reference to the rules that are coming into play today have done so. Those that are online have also been provided the opportunity to ask those questions, and those questions have been answered. Lastly, there are several measures I will need to read into the record as required by TCA 45222. First, I will read the regulatory flexibility addendum and ask that you bear with me as I do this. Pursuant to TCA section 45401 through 45404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small business. The type or types of small businesses and an identification and estimate of the number of small businesses subject to the rule being proposed that will bear the cost of or directly benefit from the rule being proposed. The board is not aware of the number of small businesses that are subject to these rules. These rules will affect all professional bondsmen in the state of Tennessee, regardless of size, and company license fees will be based on the number of bondsmen working for the company. Therefore, smaller companies will pay less than larger companies. The projected reporting, record keeping, and other administrative costs required for compliance with the rule being proposed, including the type of professional skills necessary for preparation of the report or record. Individual applicants for licensure will pay an application fee of $250. Companies will be charged an application fee of $500 plus an additional $100 per individual bondsman, bonding agent employed by the company. It is unknown what new record-keeping cost will be required for compliance with these rules, as companies and bondsmen were already required to complete background checks, continuing education, and maintain appropriate records for the individual courts where they perform services already. A statement of probable effect on impacted small businesses and consumers. The board does not foresee a significant impact on small businesses with these rule amendments or rules, although most company licensees will likely be small businesses. These rule amendments or rules apply to all licensees, and fees are scaled so that smaller companies will pay less in fees than larger companies. A description of any less burdensome, less intrusive, or less costly alternative methods of achieving the the purpose and objectives of the rule being proposed that may exist, and to what extent the alternative means might be less burdensome to small business. The board knows of no other less restrictive or burdensome means than through the promulgation of these rules. A comparison of the rule being proposed with any federal or state counterparts and legal counsel for the board conducted a review of the rules promulgated in Arkansas and Alabama in an attempt to use those as framework and guidance when advising on these rules. The board is unaware of any similar existing or proposed federal rules. As was mentioned during the comments section, we did do comparisons of the cost in some other jurisdictions. Alabama was one, Arkansas was one. We also looked at Virginia. And of all of those that we looked at and compared to the cost in Tennessee, Tennessee was still the least costing state for these rules. Analysis of the effect of possible exemption of small businesses from all or any part of the requirements contained in the rule being proposed. The board does not foresee the need for an exemption from the requirements in the proposed rules for small businesses. The rules apply equally to all licensees, regardless of the size of their business, and fees are scaled so that smaller businesses will pay less in overall fees than larger companies. impact on local governments. Pursuant to TCA Section 4-5-220 and 4-5-228, on any rule and regulation proposed to be promulgated, the proposing agency shall state in a simple declarative sentence, without additional comments on the merits or the policy of the rule or regulation, whether the rule or regulation may have a projected financial impact on local governments. The statement shall describe the financial impact in terms of increase in expenditures or decrease in revenues. The Board of Professional Bondsmen foresees no impact on local governments from these rules. I will now read the impact on local government statement pursuant to TCA 4-5-228. The program perceives no significant impact on any local governments as a result of these rules. One moment, please. I will now read the answers to the questions required by the Joint Government Operations Committee. All agencies upon filing a rule must also submit the following pursuant to TCA 4-5-226, Section I-1. Additional information required by the Joint Government Operations Committee. All agencies upon filing a rule must also submit the following pursuant to TCA 4-5-226 I-1. A brief summary of the rule and a description of all relevant changes in previous regulations effectuated by such rule. These rules create the framework to implement applications for professional bondsmen and professional bondsman companies. These rules set fees for the initial licensure, qualifications for licensure, and grounds for denial of applications. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant hereto. Public Chapter number 491 of 2025 requires the promulgation of rules to carry out its purpose. The board is not aware of any federal laws mandating promulgation of these rules. C, identification of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. Professional bondsmen will be most directly impacted by these rules, as they will be required to obtain licenses pursuant to these requirements. Defendants who need services of bail bondsmen and the courts where these bondsmen operate will be indirectly impacted by these rules, as they will be affected by the services of those who are licensed pursuant to these rules. D, identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. The board is not aware of any opinions of the Attorney General and reporter or any judicial rulings related to the rules or that require promulgation of these rules. E, an estimate of the probable increase or decrease in state and local government revenue expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the physical impact is minimal if the physical impact is more than 2% of the agency's annual budget or $500,000, whichever is less. The board does not anticipate these rules will have a significant physical impact on local government revenues. These rules will increase state revenues as these rules establish the licensure fees for professional bondsmen. However, these fees are necessary for the board to be self-sufficient and cover its expenses. The board does not anticipate that these initial fees will be more than 2% of the department's budget or exceed $500,000. F, identification of the appropriate agency representative or representatives possessing substantial knowledge and understanding of the rule. Roxana Gamuccio, she is the Executive Director for the Professional Bondsman Board. Assistant Commissioner Reed Witcher. Myself as Associate General Counsel, and Jesse Gentry as Chief Counsel. G, identification of the appropriate agency representative or representatives who will explain the rule at a scheduled meeting of the committees. It would be the same individuals just named, plus Candace Dawkins, the Legislative Director. H, the office address, telephone number, email address of the agency representative or representatives who will explain the rule at the scheduled meetings of the committees is all listed in that same order as it goes through to include Candace Dawkins. I, any additional information relevant to the rule proposed for continuation that the committee requests. There is no known additional relevant information at this time. So at this time, I would ask the board to vote on the rules that have been presented today, including the amendments that have been so added.
Is there a motion to that effect?
I'm sorry,
Go ahead.
and the statements that were made.
Move we approve. I second.
Any discussion beyond what has already occurred?
I have one thing. I don't know if this matters, but on these rules, it's got the wrong date at the bottom. I didn't want anything to be wrong and us have to do this again. It says February 25. Oh, the form date. Okay.
Hearing no further discussion, all in favor say aye.
Aye.
All opposed? Ayes have it. So the rules are adopted as amended.
That concludes the additional information for the Joint Government Operations Committee. And that concludes this rulemaking hearing. Following this hearing, the rules will be held for a certain amount of time and then forwarded on. The rules will be added to the State Form SS 7039 and submitted to the Governor's Office for final approval and review, and then submitted to the Attorney General's Office for review and approval. Once the Attorney General's signature is obtained, these rules are filed with the Secretary of State and generally become effective 90 days from the date of filing after receiving a positive recommendation from the Joint Government Operations Committee. Before I totally step away, as the legal counsel for the board, I would also request approval from the board to continue further rulemaking processes and promulgating more rules.
I make a
Present to the
motion.
board, I'm sorry.
I'll second.
And is that the next item on our agenda? Is that what you're asking us to address?
Yes, Your Honor.
Okay. All right, so the motion is to continue the rulemaking process by Mr. Williams. Is there any discussion? My only discussion is that there was one provision that Mr. Gentry discussed about the notification related to companies, and I think that's based upon the discussion of everyone else. I think that's something that, just going out on a limb here, but I think other people seem to support that based upon the discussion. I think it's at least something that should be included, and we can determine at the next hearing or whether or not we want to include that. I don't know if we need a motion for that particular item.
We do not, Your Honor. I can get that in the form of suggested.
Thank
Or
you.
suggestions.
Any other discussion? All in favor, say aye. All opposed?
Thank you, Judge and Chair. I will make sure that we don't have any other comments before we conclude. I do want to add one thing that I've not mentioned. Verification of licensure, whether approved or applicant in process, is available through our website at verify.tn.gov. There's also a link when you're on any one of our websites that says to review and verify a license. When you click it, it takes you to the cloud, which is what verify.tn.gov does. That is how judges like yourself, any other clerks would verify if there is an approved license for a company or individual, or if they're an applicant in process, as they're deciding things next week. So that would be the list that they're waiting on. It's all available online, just to add that piece. Dana, since I can't see, is there anyone that has any questions or comments at this time before we wrap up?
Yes, I am unmuting Jason Holt.
Thank you.
This is just a question in regards, I'm still unclear on the licensing fees if we are a DBA. We've talked a lot about statute, and I think it needs to be presented that there actually is two different kind of bondsmen, professional and surety. I myself am professional. Miss Alexander, as she stated, is an LLC, so therefore she is a surety bond writing through an insurance company. The state level or the federal level recognizes me to be one and the same as my bonding company. With that being said, do I pay a separate fee, or do I list one agent, which is what I have other than myself? According to the statute 4011-302, excuse me, subsection B depicts the difference between a professional bonding and a surety bondsman. So I'm just unclear on if I would list myself as an agent to my own company or no. That was all I had. That was the only question I had.
Thank you, sir.
Yes.
Legal is looking at that. Hold on.
Okay.
So in looking at the rule, and this originally came up also during emergency rule hearing, and the definition as we had it in there was amended with a motion that Ms. Alexander had made at that time. Professional surety company is included in this, as is a professional bonding company, so those fees would apply.
So I would pay the company fee, pay the $250 fee, and then the $100 fee for myself, correct?
Correct, if you are the only one posting bonds.
Okay, and just to clarify something else, I believe Mr. Gentry, you spoke and said that, or somebody did, I apologize if I've got the wrong name, representing yourself as a bonding company. I just want to make clear that we as professional bondsmen do have the ability to represent ourselves in court matters, unlike a surety bail bondsman. I just wanted that to be on the record.
Thank you.
Yes.
Any other business?
Is there any other further public comment? Seeing none, that was the end of appears to be the end of our agenda. Am I correct?
Correct, Chair. I believe we've taken comments, concluded all business that I had, legal counsel had. If the board has anything else to discuss otherwise.
I make a motion to adjourn.
Is there a second?
I'll second.
All in favor, aye.
Thank you, members. We are adjourned. Thank you, Dana.
Yeah, you used to say if somebody come to court, they'd say, they would go, do I need an attorney?